Anyway, thank you very much. We now start our session. He has his apologies for the afternoon. He's engaged in some business. We have the second submission for this afternoon, for the day, and that is from the Fiji Women's Rights Movement. And we have before us Ms. Veena Singh, Gender and Transitional Justice Team Leader, and Ms. Michelle Reddy, the Program Director. Am I politically correct in calling you Miss, etc.? Because I think the Women's Rights Movement are very apprehensive of the fact that we have to call them Miss or Miss. Is that right?
Yeah.
Okay. Alright, with those words, we will now allow you to make your presentation. We'll also appreciate, while you're making your presentation, if you could refer to the sections of the promulgation and the amendment bill, which you are referring to, so that we can, so the committee members can cross-refer and see if any corrections as they are needed. And if you are referring to the documents, we appreciate if you can point us out to those documents. I have before me your written submissions, I believe. Is that 4-page one?
Yes, that's correct.
Okay. Thank you. You may now start the presentation.
Thank you very much, honourable members of Parliament and members of the Standing Committee on Justice, Law and Human Rights. We thank you for the opportunity that you've given to the Fiji Women's Rights Movement to make an oral submission on the Employment Relations Amendment Bill 2015. My name is Michelle Reddy, and my colleague on my left is Veena Singh, so we will take turns in our oral presentation today. Veena Singh will start off, and then I will add on to the specific provisions that we have made recommendations to. The Fiji Women's Rights Movement was established in 1986 and is a multi-ethnic and multicultural non-governmental organization committed to removing discrimination against women through institutional reforms and attitudinal changes. The movement practices and promotes feminism, democracy, rule of law, good governance, and human rights. We strive to empower, unite, and provide leadership opportunities for women in Fiji, especially for emerging young leaders. FWRM's work in the area of employment reform as it relates to advancing women's rights began in the late 1990s under its Women's Employment and Economic Rights Project. The goal was to redress the social and economic disadvantaged women in the wake of labor reforms occurring in Fiji at that time. The Employment Relations Bill, introduced in Parliament in 2006, incorporates 4 specific provisions concerning maternity protection, equal employment opportunities, equal pay for work of equal value, and the penalizing of sexual harassment in the workplace. Women in Fiji make up 52% of the labor force in Fiji. Women have particular vulnerabilities, and any regulatory framework must address the vulnerabilities that women face. Laws that establish that women and men have equal rights provide an important basis for demanding and achieving equality in practice. They can be a central reference point for political and cultural struggles, driving changes in social norms and popular attitudes as well as policy shifts. But making women's rights real requires more than just legal reform. As such, FWRM believes that along with institutional reforms, there needs to be accompanied political will within workplaces in addressing attitudinal changes for progressive realization of women's rights in Fiji. For our presentation this afternoon, we wanted to refer to specific provisions in the current bill and also in the promulgation. To begin, we want to refer to Section 78 of the bill, which looks at the definition of unlawful discrimination in rates of remuneration. For FWRM, we find that the use of the words sex, gender, sexual orientation, gender identity and expression, disability, age, marital status, or pregnancy is to be commended, and it is in alignment of the Constitution. Therefore, FWRM recommends that the same language be incorporated under Section 75 of the Employment Relations Promulgation, And also having noted that the current definition under Section 75 of the promulgation misses out on keywords that's under 78, and those keywords are sex, gender identity and expression, and pregnancy. And we find for FWRM, we believe that sexual orientation and gender identity are integral to everyone's dignity and humanity, and must not be the basis for discrimination or abuse in the workplace.
Are you suggesting that Section 75 also be amended to bring it in line with the proposed amendment, Section 78?
Yes, there's some words in 75 that are missing. The second portion that we wanted to also refer to is looking at Part 19, which looks, Part 19 of the bill, which looks at essential services and industries. FWRM notes with grave concern, however, that this current bill actually further expands on essential services and industries, including the ones that are already under Schedule 7 of the Employment Relations Promulgation. Essential services and industries, as presented by the ILO representative and also by ILO itself in their definition, are those that the interruption of which would endanger the life, personal safety or health of the whole or part of the population. We therefore recommend that the Standing Committee review the definition of essential industries and services and also review the scope that it covers, specifically looking at the current listing that falls under Schedule 7 and also in the current amendment bill. We
are saying that the current definition of essential service industry as proposed in the bill, is that going to cause some sort of injury to the workforce?
No, what we're saying, Mr. Chairperson, is that the essential services definition right now is quite broad. And as in the previous submissions that were held, that was given by ILO, that there's certain services that do fall under classification of being essential. So what we're recommending is that the Standing Committee really look at the listing under Schedule 7 and also the expanded listing under the bill, and provide a mechanism or procedure for actually determining whether that industry or service is actually essential.
Because the ILO instead seemed to suggest, or in fact it did suggest, that essential industries internationally usually have to deal with industries or services that actually are life and death matters, like hospitals, electricity, water, etc. And the industries that do deal with economy or trade, like for example Air Pacific that has been brought up time and again, that shouldn't fall in essential services. Is that what you're trying to say?
Yes, what we're trying to say is the current listing is too long, and there might be some services and industries in there that are not really deemed as essential. And what we're also saying is perhaps include a mechanism or a procedure within the current bill that allows the participation of workers and employers in assisting in identifying or defining the term essential services industries. Also, in addition to that particular Part 19, there are sections E and F, which is on page 5 of the current. Yes, page 5 of the current bill. E speaks to a duly authorized agent or manager of an employer, and F looks at a person who owns or is carrying on, or for the time being responsible for the management or control of a profession, business, trade. We find
page 5.
Page 5 of the bill.
Definition of employer.
Yes, under the definition of employer. We're not very clear about what that means, and I believe one of the things that we would like to recommend is really, and also reinforcing the presentation that was given yesterday by Mr. Ecton. I don't think that there is any need to have E and F on page 5. Mr. Chair, shall I move on?
Before you move on, in respect of E and F, we had a brief discussion on that yesterday with Mr. Ecton. It seems to me that E and F are put in line to assist the other legislation as well. If you look at E, it talks of duly authorized agent or manager of an employer. In cases of foreign companies that as the new companies bill intends to bring in, sometimes the only person we have here is the local agent of foreign company. So if that local agent employs a few people, then in its broad sense, those people will be left out if that local agent is left out. It's not, I don't think it falls under essential industries yet, but if at some stage it does, then we'll have to make an amendment to include that. This is regard to E. And F, person who owns or is carrying on for the time being responsible, or for the time being responsible for management and control of professional business. This was discussed this morning, that it could include firms like law firms, accounting firms, which are not yet under ENI, not ENI, but essential industries. But if at some stage is thought to bring a particular sector in, then we'll have to then have an F there. So what's your view on that? That those two, employer definition E and F, seeks to encompass a future industry.
No, I understand what I think. Because when you look at the broader sense, in terms of the employer, because this falls right under the essential services and industries, most of which are based all in Fiji. So in terms of the employer, it will be the person in that company. So even if there is a third party, it would be the initial employer that should be held accountable, because it is the employer who then engages a third party to act on their behalf. And maybe I think when you do expand on it, you probably would be able to clarify that a little bit more.
Okay, thank you. We can move on.
Okay, and the next one that we wanted to also look at is in terms of the definitions of collective agreement. So under section 4 of the Employment Relations Promulgation, which is on page 1739. So section 4 of the Employment Relations Promulgation, and then the current bill, which looks at section 185. We find that might be an inconsistent. Is the particular section 185 under collective agreement in addition to what's under the promulgation? And does that actually replace the definition under the promulgation? Or, it just doesn't seem very clear and feels inconsistent from our particular.
The definition of collective agreement under the ERP page 1739 is more comprehensive than the one in the bill.
In the current bill.
Probably means, I'll have to verify that, but it probably means that for the purposes of that section, it's a different, part 19 is being, it's a new section has been brought in. But yeah, there is some inconsistency and the portion might have a bit of difficulty there.
Thank you. We also agree. Our second portion is looking at workers' right to strike, which also falls under essential services and industry. This particular section, this particular submission, what we want to highlight to the committee is not referring to any specific section under the bill. In essence, what we're trying to share is specifically looking at workers' rights to strike, especially those workers who work under essential services and industries. And one of the things that, whilst you have national legislation that will place some form of limitation on workers' rights to strike, and ILO stands by, in terms of practice, also recognizes that in certain times, especially concerning essential services and industries, you need to limit that particular right. At the same time, I believe that the ILO rep had also mentioned that, and we support his submission and recommendation, that while there is a right to strike, when there is restrictions or prohibitions on the right to strike, that the workers concerned should be awarded compensatory guarantees, such as perhaps conciliation or mediation mechanisms or systems. And so that's what we wanted to just highlight to the committee. In terms of section 127, which looks specifically at offices of a trade union, so section 127 under the promulgation, which falls under page 1771. So it has a listing of all, who can become officers of a trade union, who can occupy the offices of the secretary and treasurer. For us at FWRM, we believe that this section is in contravention of the ILO Convention number 87, which looks specifically at freedom of association, and also Convention number 98, which looks at the right to organize and collective bargaining. We also support the ILO submission in reiterating that really it is a prerogative of the trade union to be able to define for themselves who the officers of the union would be, the governance structures, the mechanisms that it would then put into place to become fully effective trade unions.
Are you saying that the whole of 125, section 127, should be taken out, or are you referring to a specific subsection of that?
I don't think that the whole of it should be taken out. I think that when you're looking at the particular 127, that I think that in terms of any trade union, it should be, when you're defining criteria for who can become part of the trade union, it should really be the trade union's prerogative. It should be their political will to decide for themselves who can become members. So for example, B would be something that you might want to think about. 127B. Also 127 subsection.
B has been deleted. B will be deleted.
No office of the 127B?
127.
Oh, I see.
If you look at page 2 of the proposed amendment, section 6 deletes paragraph B. So all we're left with now is I, C, and D.
127. Yes, B is deleted. I stand corrected. Thank you. I think the other one that I also wanted to, and maybe you could clarify this for us, was really looking at 2, subsection 2, which is the offices of the secretary and treasurer of a registered trade union, may be filled by a person who has not been engaged or employed in an industry, trade, or occupation. When you look at the current, I think that that particular clause limits a lot of people from who may have the skills and expertise in being secretaries and treasurers of a trade union?
Well, I see the meaning. The offices of secretary and treasurer of a registered union may be filled by a person who has not been engaged or employed in an industry, trade, or occupation with which the union is directly concerned. So that actually leaves it open for the union to employ people from outside. But then, I'm not really sure of what the concerns would be. If, for example, if a person is, say, of the nursing association, and if a secretary or treasurer is not a nurse, how would that impact that union? But it does leave room open for outsiders who might be accountants by profession, or secretaries by profession to come in.
No, I completely agree. I also say that in terms of opening it up, you're also closing a certain number of people out of the possibility of holding
and
those positions.
It's probably better to leave it to the union to decide if they want a nurse to be the treasurer of that union or get an accountant from outside, which of course might be more expensive for the union then. So it should be left to the union to decide.
Yes, Mr. Chair.
Before moving on, what do you think of 127 subsection 1C? An undischarged bankrupt must not be an officer of a trade union.
To be honest, I haven't spent much time thinking about that, but can I get back to you before the end of the presentation?
Yes. Well, what I can tell you is that most laws, or almost all laws of the country, do not see undischarged bankrupts in a very good light, and there's obvious reasons for that. Even in the company's law, the new company's law, an undischarged bankrupt cannot hold an office in a company. The reason being that undischarged bankrupts are those people who have receiving orders against them, bankruptcy orders against them being granted, but they haven't settled their debts with their creditors. Now, these kind of people are very dangerous to any economy because they're basically judgment proof. So if they run away with your money and you want to sue them, you can get a judgment against them, but you cannot enforce them because you're just doing a line of creditors. And sometimes you can't even get judgments against them. So this, a person of that nature or character, if he becomes a treasurer of a trade union, don't you think that
of course will be
problematic for the union?
Yes.
So 127, one in its entirety is not bad. It could be streamlined or edited to bring in some new things and leave some old things behind.
Yes, I believe so.
Yes. Okay, we can move on.
Okay, and then the next section that we actually also wanted to look at under the promulgation is looking at section 175, which is on page 1782. So we're looking specifically at 175, which refers to secret ballot. One of the things, 175 subsection 3B, which falls on page 173 on the top, and it refers really, it looks at a particular percentage. One of the things that we wanted to perhaps share is that in terms of requiring more than 50% of all members entitled to vote, I think one of the challenges would be really the practicality of that particular quota and whether that is actually possible.
There was a suggestion by the ILO expert that it should be 50% of the quorum and not 50% of the membership. We will then be able to help your situation where you might have 100 members, but only 50 turn up to the meeting. You will have a quorum, but you will not have 50% of the votes.
Yeah, I think that would be a better move or option to take rather than the whole 50%.
Okay.
Okay, then we move on to the next section, which is looking at section 180. The 180 actually falls on page 1784 of the promulgation and really refers to the power of the minister to declare strike or lockout unlawful. FWRM supports the ILO submission in saying that it really does recommend that the power to declare a strike or lockout unlawful should really lie with an independent body rather than the minister.
If there has to be an independent body, each body suggests there's three bodies that are at the moment available. This is the Employment Relations Tribunal, Employment Court, and under the current amendment, it will be the Employment Arbitration Court. So which of those three would be a better option?
I believe the Arbitration Court deals specifically with essential services and industries. And again, I won't be able to answer that particular question, and I leave it to the experts to be able to choose which structure works well. But we reiterate that we believe that you'll be better
out of the minister's hands.
Yes. The next section that we also wanted to refer to is really looking at the specific bill. Section 191BC and Section 191BD, which looks at arbitration court. I believe that falls under the current bill on page 24. So page 24 of the Employment Relations Amendment Bill. In terms of section 191BC and 191BD, the current bill allows essential services and industries a separate access to arbitration court. Unfortunately, what we find is that the employer and the trade union rep cannot be allowed legal representative, specifically looking at 191BC section 1. But we also know that a legal representative is possible by the leave of the arbitration court in proceedings in which the Attorney General has intervened. From our perspective, this leaves a very narrow scope for the right to access to justice. Furthermore, if you read in the particular sections, you'll find that any legal matters that come under the arbitration courts, if not resolved, are automatically referred to the Solicitor General, which is looking at 191B. We feel that this could be and is clearly a conflict of interest.
I don't follow that. There's two parts to your submission.
So under 191BC, we're saying that whilst the bill does allow an arbitration court, a separate court, to deal with matters, we also find it problematic that that the employers and trade unions, and that's 191BC1, that employers and trade union reps or officers cannot be represented by a legal practitioner, except under the
Attorney General's office can be.
Sorry?
The Attorney General's office, by leave, can have a lawyer.
Except in proceedings where the Attorney General intervenes.
It seems pretty unfair, isn't it?
We find it highly unusual. Yeah. And added to that, if any matters under the arbitration court is not resolved, it automatically goes to the Solicitor General's office, which also falls under the Attorney General's office. So we find that this could be and is deemed to be a conflict of interest. So it's quite critical, and we recommend that the Standing Committee have a look at the sections in particular. Then our next submission is really looking at bargaining units versus trade unions. And we believe that both options are available in the proposed bill. I believe that the challenges that both options allow have been clearly highlighted by the ILO representative and also Mr. John Apted. We also find that the purpose and the scope of bargaining units, the way that it's formed, the functions and the governance structures are not clearly defined. One of our recommendations would really be to remove the bargaining units, because we feel that it only further erodes the rights of employees. If you have trade unions, what's the point of having a bargaining unit when there are no clear guidelines or criteria already established? Okay, and then the next one is looking at section 241, which I believe 241 of the Employment Promulgation, which falls on page 1798. Just give me a few minutes to find myself as well. Yes. So under section 241, under the promulgation, I believe that in the current bill it's saying on page 4, which is looking at section 13, it says section 241 of the promulgation is amended in subsection 1 by deleting the words or part 19. So we find this very problematic because it's quite a significant flaw in the bill if you remove part 19 from the current promulgation, because it removes the ability of affected persons under the bill to seek to appeal the decision of the minister in a court of law. And also, as I had mentioned earlier, by widening the definition of essential services in industries, it really could only curtail the operations of such various services, and also the inability to challenge the decision of the minister. We feel that this further and can further entrench the powers of the executive. They are both judge and jury, and really contravenes the rules of natural justice. One of the things that we feel very strongly about at FWRM is that legal representation and the right to appeal are two key cornerstones of the justice system. So by removing Part 19 from Section 241, we find that that is quite problematic for us, and we would recommend not going ahead with removing that particular portion. The next thing that, and this is also something that perhaps the chair and the Senate committee could also explain a little bit, or maybe have some insight on. One of the things that we felt, and maybe we didn't catch it quite well in the amendment bill, is we feel that it does not address the previous agreements that existed before the promulgation came into effect. Would you have any background to?
Yes, you mean the decree came into effect, or the promulgation? Because the promulgation, the employment relations promulgation that came into force in the year 2007, and under that were the collective agreements made. And those collective agreements, as submitted earlier by the union this morning, was that in November, also in 2011, September, when the ENI, the Essential Industries Decree came about, those collective agreements that were entered under the promulgation, including the workers' rights and rights to negotiate, etc., they were all declared null and void by the Essential National Industries Decree. Now, with the removal of and then the court cases that were pending were given certificates that they cannot continue further. Now, with the removal or the repealing of the ENI, is a question that should those court cases or those agreements that have been declared null and void, should they be brought back to life?
I think so. I think that one of the things, well, that's also a question I wanted to ask. I mean, the decree does remove ENI, but what happens to all those agreements that were made before that? Surely there should be a mechanism that allows employers and workers to be able to look back into those agreements or revive those agreements.
The amendment itself, it doesn't have any section that says that it will have retrospective effect. It doesn't say that those things that have been dealt with will be brought back to life. But the general philosophy of law, the general principle how law operates is that you take the law on the day the issue arose. So if, for example, the law before this amendment comes into practice was that those matters could not proceed, and the law subsequently changes, then those cases that have been struck out and those agreements that have been declared null and void will not come into force. They will not be given life to, because there is a public policy reason for that as well. Because laws are not static; laws change over time. So if somebody, for instance, had a motor vehicle accident and that wasn't covered in the 70s, and suddenly law is changed this year, it will be against public policy to revive all those cases of accidents that have happened in the 70s. So that's an issue that we need to relook at. But yes, the question of whether by repealing the ENI, those existing or those cases or those agreements should be brought back to life is something that can be submitted early on, and definitely the committee will consider the effect of it before making any changes to those. Because otherwise, what will happen This is one of the effects. I'm not saying that will be the final deciding line, but there has to be finality to decisions. We understand that E&I was a special area that stopped cases that were proceeding that were even nearing completion, and as suggested by FPSA, some agreements took 2 or 3 years of hard labor and cost to finalize, and it became null and void just by decree, and with the decree now gone, or which suggests the bill is suggesting to repeal. Should those be revived, we'll have a look into that.
Thank you. Thank you very much. And our last section that we actually, and also recommendation that we want to share with the Standing Committee is